It is already Q4 of 2024, and today we are talking about some quick tips to consider for immigration compliance. So this video is intended specifically for HR professionals, global mobility professionals, general counsel, business owners, anyone basically who is involved in or in charge of immigration compliance for your workforce, no matter how big or small it is. Of course, this information is for educational purposes only. It is not legal advice, but these are some things that you perhaps should at least be considering. So welcome to everybody who is joining me live. Welcome also to those of you who are catching the replay. I'm glad that everybody's with me. If you have questions as we go along, feel free to put those in the comments, and I will certainly address those if we can as we go along. My name is Emily with Sumner Immigration Law, and let's dive in. So I have about 6 tips to consider. The first one is consider the possibility of conducting an end of the year I-9 compliance audit. So I-9, of course, is the form that you have to complete whenever you hire anyone to work for your company. And I-9 compliance is absolutely critical. Whether you participate in E-Verify or not, that may be optional for you depending on your state and your particular situation. Know that if you hire STEM OPT employees, you do have to participate in E-Verify, but regardless, it is in general a good idea to periodically review your I-9 documents to ensure compliance. That doesn't have to be done right now, but it's at least something to keep in mind that you should schedule to be done periodically, making sure that you have all the required documentation, forms are completed correctly, and making sure that you are getting rid of documents or getting rid of records if and when you can. Make sure that you pay attention to those regulations so you're not purging information that you actually will need later on. H-1B compliance and amendments, and this actually touches on any type of immigration filing that requires an LCA, a labor condition application. So that includes the E3 and the H-1B one in addition to the H-1B. So when I'm talking about H-1B and compliance and amendments, you might also want to conduct an audit of your public access files, which you have to keep on file and make sure that those are updated. Related to that, if a person has changes in their salary, so for example, if you give raises at the end of the year, you would need to make sure to annotate your public access file for any foreign national workers who are on H-1B1, or E3. In addition, pay attention to if there are material changes that might need to be or might require an amended petition for the H-1B and other visa classifications. When I say a material change, that can include things like a change in the worksite location, a change in the job title or job duties, a change in the salary, especially if the salary is going down or the wage rate is going down. And also changes from part-time to full-time or full-time to part-time. All of those and others can be considered material changes that could require an amended petition. So those are changes to be paying attention to throughout the year, but it might be good to go through your list of foreign national workers and see if there's anything that perhaps you haven't caught that you need to address now. In terms of PERM, the labor certification process, so that's not to be confused with the LCA. The LCA is tied to temporary visa classifications like the H-1B, H-1B1, and E3. The PERM labor certification process is the first step in a lot of green card, employment-based green card processes. So all of those processes, the PERM process has a lot of different deadlines in terms of recruitment, when to file, the expiration of prevailing wages. Make sure that you are in communication, really constant communication with your immigration attorney or the person internally, if you do these internally, who's handling this type of case, to make sure that everything is on track for filing when you anticipate you should be able to file, and to make sure that you're in compliance with all of those deadlines. It also might be good, towards the end of the year. I know our office is closed for Thanksgiving, and then we're closed for a period of time at the end of the year. So it's good to make sure that if you do need or want to conduct recruitment towards the end of the year, to come up with a plan for that now, because people will be in and out of the office. It's just a crazy time of year in general. So come up with a plan to make sure that that recruitment is completed in a timely manner. My next point, and I'm turning my page of notes here, is planning for the 2025 H-1B lottery. So that lottery will open in March of 2025. I know it feels like fall just started and March seems forever away for a lot of different reasons, but it will be here before we know it. And planning proactively for that H-1B lottery can save a lot of time, stress, and headaches for later. So start looking at your list of foreign national employees or prospective employees, see who you may need or want to register in the H-1B lottery. Make sure to allocate for that in the 2025 budgets that you're probably setting at this time. Remote work compliance. So remote work, I know, is a hot topic. Our team works remotely 100% of the time. I know some companies have called people back to the office. Some have a hybrid type situation. We frequently get questions from employers and employees saying, hey, I'm going to move to a different state and I work from home. What do I need to do for my immigration compliance? And I'm so glad that they asked me that question proactively, because there may need to be changes to be made. So for example, if you have somebody on an H-1B, or again, anyone with an LCA-based filing like H-1B, H-1B1, E3, you may need to file an amended petition. It depends on how much the worksite is changing. So definitely talk to your immigration lawyer to see if you do need to file an amended petition. But keep in mind that you may need, for foreign workers, foreign national workers, you may need to keep in mind, or you will have to take into consideration different considerations than you would for somebody who is not working under an H-1B, for example. If they change work sites, you might need to file an amended petition. There could be wage considerations that you have to keep in mind. So communicate that to your immigration lawyer, and if we are your immigration lawyer, will certainly help you out and help you determine what, if anything, needs to be done. And honestly, sometimes nothing needs to be done. We're still glad to know, and we're always happy to answer questions. And then finally, think about travel for foreign nationals. Of course, the end of the year is a big travel time for a lot of people in the United States and around the world. And you may have employees who are traveling to go home to see family, or for whatever reason, for holidays, vacations, whatever it is. So if you have foreign national employees who are traveling, a general reminder to them, a lot of the responsibility for this is on them, but a general reminder to them to make sure that they have a valid visa, of course, to make sure they have a valid passport. But the visa is a big thing to be able to come back into the United States. And then when they re-enter the United States, a general reminder to check their I-94, either you or them, to check their I-94. You can check that online at the CBP website, but to check the I-94 to make sure that the information entered into the system is correct. When I say the information, I mean things like the name, the date of birth, the visa classification, and the date until which they can stay in the United States. It is not at all uncommon for there to be misinformation or incorrect information on the I-94. It can be corrected sometimes pretty easily. Sometimes we can just email the port of entry and ask them to update it, and it's updated. Other times it's a bigger hassle, but regardless, it's easier to update that, to have that corrected sooner rather than later, closer in time to the date that the person entered the United States. Another thing to keep in mind is passport expirations. If the passport is going to expire relatively soon, the duration of the person's stay in the United States will match the expiration of the passport. That is not an error. So we have had situations before where people didn't realize that, and months later, sometimes a year or more later, they realize that their I-94 has expired because their passport expired. That's not an error that the CBP will correct. So then you have to correct that through USCIS or by having them travel, depends on the particular situation. My point is to make sure that there's plenty of time left on the passport. If there's not, to make sure to check that I-94 expiration. And regardless, to make sure to check the I-94 records. We are constantly working with clients and CBP to have those records updated. So that's something to keep in mind as well. So I hope that you have found this information helpful. If so, please share it with a colleague or a friend, and make sure that you are subscribed to this channel that you are watching this live on, to make sure that you don't miss our future updates. My name is Emily Sumner with Sumner Immigration Law, serving clients around the United States and around the world with employment-based and family-based immigration matters. I will be live at lunch next Tuesday at noon Eastern. If you have any questions, drop them in the comments and we're happy to help. Until next time.